Hello and welcome to Quotes Today by Live Law. Let's get to today's top legal updates. Pahalgam terror link. Supreme Court asks center to verify family citizenship before deportation to Pakistan. In the Malegaon Blast case, Supreme Court closes plea against Sadhvi Pragya's bail. Notes, NIA court has reserved the judgment. In the National Herald case, Delhi court issues notice to Sonia and Rahul Gandhi in money laundering case. Supreme Court orders no tree felling within 5 kilometers of Taj Mahal without Supreme Court's permission. Gang rape law. Supreme Court says if one commits rape with common intention, all can be held guilty. 1982 Jammu and Kashmir Migrants Law. Supreme Court closes petitions, says law was never enforced and repealed in 2019. I am your host, Syed Amir Hussain, with your daily roundup of legal updates from across the country. For detailed reading, you can always visit www.livelaw.in. Please make sure to watch this video till the very end and don't forget to like, share and subscribe to our channel because your support means the world to us. What happens when people facing deportation claim they're being wrongly removed? On May 2nd, the Supreme Court stepped in to pause action against 6 individuals who say they're Indian citizens but fear being sent to Pakistan. The case comes in the wake of April 22nd Pahalgam terror attack, after which the center revoked all short-term visas issued to Pakistani nationals and ordered them to leave by April 27th. The petitioners say they have valid Indian passports and Aadhaar cards. 2 of them work in Bengaluru, while the rest live in Srinagar, and they allege they were almost taken to the Wagah border to be expelled. The Supreme Court, led by Justices Suryakant and Kashmir Singh, directed the center to verify the documents and facts. Until a final decision is made, no coercive action can be taken. The court also allowed the petitioners to approach the Jammu and Kashmir and Ladakh High Court if they're unhappy with the outcome. However, the court made it clear that this order won't be treated as a legal precedent. After 16 years of waiting, the Malegaon Blast case may finally see closure. Today, the Supreme Court disposed of a petition filed back in 2017 by the father of a blast victim, challenging the Bombay High Court's decision to grant bail to Sadhvi Pragya Singh Thakur, one of the key accused in the 2008 Malegaon blasts that killed 7 people. The High Court had earlier said no prima facie case was made out against her. But now, with the NIA court finally concluding trial and reserving judgment on April 19th, the petitioner's lawyer told the Supreme Court there is no need to pursue this case any further. Over 100 witnesses have been examined, and the verdict is expected on May 8th. The petitioner also urged that Judge A.K. Lahoti, who heard the entire trial, should not be transferred before delivering the verdict. Though he's on a proposed transfer list, he's been allowed to stay on till August 31st. The Supreme Court today agreed to close the petition, saying there's no reason to continue. Big development in the National Herald money laundering case. A court in Delhi has issued notice to Congress leaders Sonia Gandhi and Rahul Gandhi after the Enforcement Directorate filed a fresh prosecution complaint. This comes under the Prevention of Money Laundering Act, alleging serious financial misconduct. At the heart of the controversy is the now defunct National Herald newspaper, published by Associated Journals Limited, AJL. In 2010, a newly formed company, Young Indian Private Limited, or YIL, took over AJL's debt of rupees 50 lakh from the Congress party and in return gained control of assets worth over 2,000 crores. Sonia and Rahul Gandhi are majority stakeholders in this new company, triggering allegations of using party funds to acquire AJL's prime properties. The ED, which began its investigation in 2014, claims this was a scheme to misappropriate assets for personal gain. The agency has already moved to seize AJL's linked properties worth 661 crores. In a major environmental protection move, the Supreme Court has ruled that no tree can be cut within 5 kilometers of the Taj Mahal without its prior permission. This rule is not new. It was first laid down in 2015, and now the court has made it crystal clear. Even if fewer than 50 trees are involved, you still need approval. Any request will be checked out by the Central Empowered Committee or the CEC before the court decides. For areas beyond 5 kilometers but within the Taj Trapezium Zone or the TTZ, permission must come from the Divisional Forest Officer or the DFO, but only after ensuring compensatory plantation of at least 2 trees for every single tree cut. The court also warned against backdoor exemptions disguised as agro-farming on private land. It rejected a plea from a trust seeking a blanket license to fell trees, saying such moves defeat the entire purpose of protecting Agra's environment. The court even asked for a report on extra protections for Agra Fort and Fatehpur Sikri. In a powerful ruling, the Supreme Court upheld convictions of men accused of gang rape, rejecting their claim that they didn't personally commit any act of penetration. The court clarified that under Section 376, Clause 2G of the Indian Penal Code, once it's proven that there was a common intention, even one act of penetration by one person makes all others equally guilty. Justices Sanjay Karol and KV Vishwanathan said that gang rape is about group involvement and shared intent, not just individual physical acts. The judgment relied on an earlier Supreme Court ruling in Ashok Kumar versus State of Haryana of 2003, which said it's not necessary for each accused to have committed rape. If even one did, all are guilty if they acted together. In this case, the accused had abducted and confined the survivor, and her testimony showed she was sexually assaulted. The court said their collective actions proved a clear intent to commit the crime. So, in gang rape cases, shared planning and participation are enough for punishment. Can a law that was never implemented still be challenged in court? The Supreme Court has finally put to rest a 43-year-old legal battle over a controversial Jammu and Kashmir law. The court disposed of petitions filed against the 1982 Jammu and Kashmir Resettlement Act, which aimed to allow people who migrated to Pakistan after 1947 and their families to return and permanently settle in Jammu and Kashmir. But here's the twist: the law was never enforced. The court had stayed its operation in 2002 and no authority was ever appointed to implement it. Then, in 2019, when Article 370 was abrogated, this act was officially repealed under the Jammu and Kashmir Reorganization Act. So, the court ruled that there's no point in deciding its constitutionality anymore. The law simply doesn't exist. A bench of Justices Suryakant, Dipankar Datta and N.K. Singh closed the case, noting that the act had no legal effect and had been wiped out from the books. The petitions pending since 1982 have now been dismissed. This marks the end of a decades-old controversy over whether former state subjects who chose Pakistan could legally return.